preventive detention laws. Preventive detention laws. So preventive detention means you are detaining a person on the ground of suspicion only. Suspicion that he may commit crime. Fine. So preventive detention, detaining a person on the ground of suspicion that person may commit a crime, or where the police does not have sufficient evidence. Fine. Now, preventive detention laws are the major human rights concerns. Fine. It is a major human right issue. Why? Because they enhance the police power of the state considerably. They enhance the police power of the state considerably and weaken the rights or liberties of the people considerably. That is our issue. So preventive detention laws have been introduced in India by the colonial governments. One of the preventive detention laws has been the Rowlatt Act. So one of the preventive detention laws has been the Rowlatt Act, against which even Gandhi has organized the first All India protest. So these preventive detention laws, because they have chilling effect on freedom, they have been called as black laws, Kala Kanun or black laws. Now we know that India's national movement or India's freedom movement can be considered as the largest civil rights movement in the world. Fine. So during national movement, persons like Rabindranath Tagore, Sarojini Naidu, Pandit Nehru, they were very active in the civil rights movement in the country. They were very active in the civil rights movement in the country. And especially Pandit Nehru has promised that in independent India, there will be no black law. Now, after this, when Indian Constitution has been framed, unfortunately, preventive detention has been retained. And again, preventive detention is, such laws exist not only in India, such laws exist in other countries also. But the problem is preventive detention laws exist in India, or they can be applied even in normal times. In other countries, preventive detention laws are applied only during emergency times or abnormal times. And India, preventive detention laws, they can be applied by both Parliament as well as state legislature, though the reasons may differ. So that is one cause of concern. And another thing is that there is a reference of preventive detentions in the part 3, which deals with fundamental rights, and preventive detention is a concept completely in contradiction. It is a concept which is completely in contradiction to the very idea of fundamental rights. So it is believed that this is something very, very undesirable if there is a reference for preventive detention. Now you have to understand why there is a reference. Why Constituent Assembly made the reference. So Constituent Assembly has made the reference of the preventive detention law in part 3 to ensure some constitutional protection to the persons, some constitutional protection to the persons detained under preventive detention laws. Fine. So Constituent Assembly wanted to grant some minimum protection to the person detained under the preventive detention laws. Fine. But what is the problem? The problem is it has been realized the protection available are not strong enough to protect, because there are lot of exceptions to the protection. So the problem is the protection granted is not enough, and there are lot of exceptions to the protection itself that we will discuss. Fine. So in effect, there is no real protection. And the second problem is in number of situations there have been instances where governments have misused the laws. Misused the laws means it has been misused against the opposition. It has been misused to curb the dissent. So normally sedition, section 124A and preventive detention laws like Unlawful Activities Prevention Act together harm the exercise of freedom of speech and expression in a big way. So it's a very important concern of the human rights. The problem is the inadequacy of the provisions, and as a result there have been the occasions of the misuse to curb the dissent, to curb the criticism of the government, and also as a political tool to harass the opposition. That is a point of the problem, means enough safeguards are not present under the constitution for the person who is detained under the preventive detention laws. So it is considered as a major human rights issue. Now, what are the constitutional safeguards? For a person detained under the preventive detention law. Fine. So even first safeguard says that no person can be detained beyond 3 months. And you can say the misuse of the preventive detention laws is started from the very beginning, as I have explained A.K. Gopalan case. And this started during the time of Pandit Nehru's government itself, who promised there will be no black law, but Preventive Detention Act was passed, and A.K. Gopalan was the leader of the Communist Party, that time the main opposition to the Congress, and he was detained under the Preventive Detention law. And after that, almost all the government, irrespective of the party, they have misused it. So that is a cause of concern. So it says that no person can be detained beyond 3 months. Fine. So in ordinary detention, you can be detained for 24 hours, but here a person can be detained for 3 months. But again, there is a exception, or let us say it says no person can be detained beyond 3 months. Then it also mentions the exception. The exception is police can detain the person beyond 3 months with the approval of advisory board. Now, advisory board will consist of the judges who are or who have been the judges or the members who or judges of High Court. Fine. So who qualify to be a judges of High Court. So this protection is given. So first protection is not beyond 3 months. The second protection, there is an exception, but protection that a person can be detained beyond 3 months, but only with the permission of the advisory board. Now here problem is that the accused has no right to representation in the advisory board. So advisory board will only listen to the narrative of the police. So most of the chances is the decisions of the advisory board are against the accused. Now, there is an exception to that exception, that in case any law passed by Parliament says that police can detain a person under preventive detention law for, let us say, X period, then the situation is different. For example, let us say, I am not fully sure, but let us say National Security Act. If National Security Act allows the detention of a person for 1 year, or let us say TADA allowed preventive detention for 5 years, then these things that he cannot be detained beyond 3 months does not apply. He cannot be detained without the permission of advisory board is not required. So what can happen, that Parliament can itself prescribe, for example, that under preventive detention law, police can detain a person for 1 year. If law itself says police can detain a person for 1 year, then the protection that person cannot be detained beyond 3 months without the permission of judicial magistrate or the advisory board, that is again given an exception. So there have been the laws which have allowed to remain the people detained under the police custody without being presented in the court of the judicial magistrate for 5 years also. So that is considered as the problematic part of this law. In short, the preventions or the protections available under the preventive detention related protections in the Constitution under Article 22 are not considered to be sufficient enough. Now, besides this, Constitution says that person has right to defend itself, and for that person has to be informed about the grounds of arrest. But again, there is an exception where police, because you can defend yourself when you know the ground of arrest, but the exception is that police can deny the disclosure of the facts in the interest of national security. So when you don't know the facts, how you are going to defend yourself? So these are certain controversial issues that says that though protection in case of preventive detention is mentioned, but the exceptions make it too weak a protection. Fine. So now let us see it from the Constitution articles itself. So nothing in clause 1 and 2 shall apply for any person detained who is an enemy alien, leave enemy alien, who is arrested or detained for a preventive detention law. Now in case of 24 hours here, it is mentioned that a person can be detained for 3 months. No law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless an advisory board consisting of persons who have been or qualified to be appointed as a judges of High Court has reported before expiration of the set period of 3 months that there is in its opinion sufficient cause for such detention. Fine, but there is a exception to it, provided that nothing in this clause authorize the detention of any person beyond the maximum period prescribed by any law made by Parliament. Means still police can detain a person beyond 3 months if Parliament's law tells that person can be detained, let's for 5 years, but not beyond that. Fine. Such person, nothing will apply if such person is detained in accordance with the provision of any law made by Parliament. Means Parliament can make a law and the first instance itself Parliament can prescribe that a person can be detained without presenting to the judicial magistrate, let's for 5 years also. Now when any person is detained in pursuance of an order made under any law for preventive detention law, the authority shall communicate the ground of arrest on the basis of which he can represent himself for against the order. So clause 5 says authority should tell the ground of arrest, but clause 6 is an exception which says that nothing in clause shall require the authority making any such order in that clause to disclose facts which authority consider is against the public interest. So if police think it is not in the public interest, it can stop the disclosure. So if you do not know the ground of arrest, how are you going to move ahead for your representation? Now, Parliament may by law provide the circumstances or the situations where the law can be made for the period, for the detention of period beyond 3 months, even without the permission of advisory board. The maximum period for which a person can be detained and the procedure to be followed by the advisory board. Now, under 22, checks on executive, citizens and non-citizens not available to the enemy aliens. It is applicable for arrest without warrant, without permission. It is meant only for the criminal law, not for civil or land or revenue law. Detentions, ordinary and preventive, ground of arrest, these are the rights mentioned. Consult the legal practitioner and produced before the nearest magistrate. Preventive detention, it is mentioned in union list. Union can make laws on these subject, state can make laws for these subjects. What are the safeguards? Earliest opportunity to make representation, but if police will not disclose you the ground, how will you make representation? Next safeguard, maximum 3 months detention, but again there are exceptions. Enemy alien, I have already told you, so Article 22 does not apply in these cases. Now, whether preventive detention laws are subjected to judicial review, the famous case is A.K. Roy case, which says that preventive detention laws can be subjected to judicial review on the limited grounds. You have to remember one thing: preventive detention beyond 3 months and beyond the permission of the advisory board can be, such law can be made by the state legislatures, but only with the permission of Parliament.